In this case, she wasn't an adult. She was a kid. She was a minor, and she was a captive, right? She was actually in a detention facility by somebody she trusted, right? In a candy room. It's the most disgusting thing. And so the reason I bring that up is because as a defense attorney, you have you have the whole entire landscape of things you can do to look like a great attorney here. You lied here. You lied in 2017, 3 different times, 2017, 19, and another time. She lied 3 times, and she kept it to herself. And there's a civil suit involved, and now she's lying in that context. So as a defense attorney, you almost have too much. You have an embarrassment of riches of ability to cross-examine and discredit her testimony. But me as a person looking at her testimony, if she was raped by Malavey, her behavior is not uncommon. It's not bizarre. It's bizarre if you look at it from a common sense standpoint, but this is not a common sense situation. This is a rape of a minor situation. So to answer your question, the defense attorneys have too much runway here. They have to be careful. For this jury to see this case in the proper context, they can't just look at her testimony. They're going to have to look at expert testimony, psychologists who can bring in the context, because it's not likely that a jury is going to have all the context that, let's say, I have after 20 years of practicing in this and understanding this, or even a doctor or a psychologist who have even more context than me. They're going to have to see this context through her testimony, through the cross-examination of the defense attorney, but also through the direct examination by experts who can shed light on why females make these types of decisions in these situations.